Witness is not present. Ms. Hogue.
Your Honor, is there a way we can do this at the bench, or?
No, we're making a public record of this. I adjourned because when the state was done, I heard some weeping in the back, and was looking at the defense to move forward, and there seemed to be an indication that we should take a pause, so I decided to take a pause. That is all. I have order back in the courtroom now, so I intend to move forward.
And Your Honor, for purposes of the record, I will have to note that I observed a number of jurors looking back. And that's why this is so difficult, Your Honor. We are advocates for our clients, but we are also human beings and parents. And there is no disrespect intended in these remarks, but my one and only purpose is to assure a fair murder trial for Mr. McMichael. And when jurors hear the weeping with a piece of evidence that is absolutely irrelevant and has nothing to do with the decisions this jury must make, but the law of Georgia allows it to come in, and then left with having jurors hear and see and visualize the emotion, and now to be comforted by someone for whom respect abounds. We're in a very difficult position now with this jury to have seen and heard and felt that when they go back to deliberate this case and to think about the decisions that do matter in this case. And as beautiful of an in-life photo as that is, it bears no relevance to any issue in this case. So while I appreciate the court taking a break and noting your having heard the crying up at the bench, I have to place on the record that not only did I hear it as well, I saw jurors looking back at what was going on in the gallery and then looking at me. So I'm asking the court to place that on the record. Mr. Goff and I may not agree on a number of things, but the idea that this may not be the best way to handle this sort of case has become now the issue that you asked him to bring to your attention, and that is, has there been any disturbance caused by that presence?
If I could just add, Your Honor was very aware of the issue of emotion in the courtroom and how it plays out in front of the jury. And I think went on the public record and warned the gallery not to engage in that kind of behavior, and I think instructed all of us to make our witnesses aware of any evidence that might come in that would cause that kind of emotional outburst, and did so with the goal in mind of keeping this trial about the evidence. It's becoming less and less about evidence and more about emotion with these kinds of outbursts and those kinds of photographs, which, again, to echo Ms. Hogue, have nothing to do with the issues in this case. A photograph that's 8 years old and bears no real resemblance to the person we saw in February of 2020. So I would join Ms. Hogue's difficult position. I think we're all in that same position on this side of the courtroom.
Anything from the state?
No, Your Honor.
All right. So let me tell you where we are. I heard at the bench, some weeping, not outward crying, not yelling, nothing along those lines. So the jury was asked to leave, and this was intended to, and I think is a good reminder to the gallery that there shouldn't be any outbursts, no matter what the evidence is, whether it's this photograph or anything else. But I will point out, with what's now beginning to happen here, I do not understand, Mr. Goff, why this motion keeps being made. It is a concern to the court because on the flip side, I've seen a news report where other counsel are indicating that everybody is welcome, come one, come all. We've got a little bit of, there's there's an odd thing going on here that I'm watching to make sure that I've got a clear understanding of as we move forward in this trial. And I've already put my rulings on the record with regard to public access in this courtroom. That has now somehow got conflated with a photograph that was not objected to as it came into evidence. I understand the defense.
It was objected to previously, Your Honor.
That particular photograph. Okay, and that's fair enough. And I misspoke there. And I misspoke. But the point being that there's other evidence that comes in, elicits responses. I've got issues that are starting to get conflated, and we'll watch what's going on. The court's rulings, again, on public access haven't changed. The evidence is being admitted. It is an emotional trial. That is not unique when it comes to murder trials, which is why the court prefaces a lot of murder trials with, I don't want any outbursts from the gallery. So again, to the gallery, I don't want any outbursts from the gallery. This is not the place for it. We're trying to get a fair trial for the defendants and ensure that the evidence gets presented in such a way where counsel have the opportunity at some point, hopefully in the near future, to make an argument to the panel about what the evidence actually says happened on the day or days involved here. That's what we're doing. And I don't have anything else to say about it, Mr. Goff.
I might suggest that the court consider some Supreme Court precedent.
On access to the courtroom?
Maxwell v. Shepherd, Stella v. Texas, and I don't remember the other name of the party, but Musladeen, and Justice Souter's concurrence.
Well, why don't you tell me what your understanding of it is, and then I'll go ahead and take a look at it, or give me the full cite if you're going to ask this court to do something in the form of a motion. If you're not moving the court to do something, I'm not terribly interested in continuing this conversation.
Your Honor, I will file a written motion as soon as I can finish it. You might well imagine that we're talking about issues that we don't ordinarily encounter, even in a criminal case.
Well, don't throw up a trial balloon without some support at this point. If you think that those cases in this context move the court to do something, cite them, let me know what it is, and we'll move on from there. Because I've heard a lot of discussion here, and this is the first you're now citing case law on this. So, if you want to file something, go ahead and file it.
Thank you, Your Honor.
Thank you. Is the state ready with this? I'm sorry, it's not even ready. Let's get the witness back up. State to pass the witness, yeah. And let me back up. If you're moving for a mistrial, you need to move for